Hello, and welcome to our discussion today about mandatory retirement age provisions for partners. This will hopefully be of interest to you if your firm is currently considering whether to revisit the mandatory retirement age in your LLP agreement because of perhaps recent case law. You might be the firm itself, you might be HR or the GC or the managing partner, or you might be one of the partners who is the subject of maybe a consultation process around this. So hopefully you'll find this high-level discussion around partner mandatory retirement ages, how to look at them, how to review them, how to justify them, interesting. My name is Clare Murray. I am the managing partner of specialist partnership, employment and regulatory firm CM Murray, and I am joined today by two of my fabulous partners, Emma Sangeelee, who is an employment and partnership dispute specialist, and Corinne Staves, who is a partnership governance, structuring and M&A specialist. Hi, Emma and Corinne.
Hi.
Right. So, Corinne, I'm going to turn to you first, if I may. What do you see? When you're advising firms on their governance reviews and on their other partnership issues, what do you see in terms of market standard around partner mandatory retirement ages?
Thanks, Claire. We see a real range of approaches with respect to mandatory retirement ages, or MRAs, as you might hear us abbreviate it to this morning. There's some data produced by the Association of Partnership Practitioners that's been collected since 2011 in 4-year intervals. And we've seen the use of mandatory retirement ages in that data sort of start quite high at sort of 70% of firms and drop down to 20% of firms in 2019. But then the data suggests a slight increase in that use of mandatory retirement ages, sitting at just over 40% at the moment, according to that data. I should stress that data is probably not statistically significant in terms of the data set, the firms that were surveyed, but it's still, I think, the only data that's available on those sorts of questions in the market. So I think it is interesting. And for what it's worth, it is borne out by our own practice and what we see in the market. And actually, we talked to a group of people at a recent face-to-face seminar, and the data that they provided to us in Slido actually supported those figures actually quite closely. We were quite surprised at how close the data was in that sense. In terms of the age that we see used where a firm does have a mandatory retirement age, I think it's fair to say that we've seen that creep up over the last 10, 20 years, if you like. I think that makes sense given sort of the rising costs profile for people just living their lives, and things like people having second families and those sorts of things, meaning that people want to work for longer. People are generally healthier into older age and those sorts of things. So I think that people want to work for longer than perhaps compared to 20, 25 years ago. We don't see them very often in US firms. I think that's largely down to the cultural differences, but also the compensation systems. The really strongly eat what you kill models means that lots of people remain in the business for a long time, and their contribution links to their compensation. So it doesn't matter whether you're contributing, less if you're older, which is the rather lazy trope that we quite often hear, or not. Frankly, it all links to your personal contribution year on year at any age. And finally, the last observation I'd like to make is the main thing I would say about mandatory retirement ages is we don't usually see the provisions applied in the way that the documents expect them to be applied. So we're going to talk today about what the provisions say and what the provisions should and can say. But I would also sound a note of caution that quite often in practice, we see that provisions exist, whether or not lawful, and yet they are not applied in the way that the documents expect them to be applied. And therefore, that raises a whole range of issues as well to be considered.
Thank you. And in terms of when firms do their governance reviews, whether they're looking at partnership remuneration, sort of exit provisions, things like that, to what extent do they focus in on the mandatory retirement age provisions?
Thanks, Claire. We always raise it when we're looking at governance reviews, and it's really important, as we'll hear, that that's done. But very often, I'm sorry to say, actually firms think it's too difficult to deal with, and there are really good legal reasons to deal with it, of course, and yet still firms think it's too much of a nettle to grasp. sometimes that means that the exercise around it is not as robust as it should be, or that the firm ends up in a less protected position than it could be. But if we're talking here about what we see in the market, the reality is that it's just too much of a hot topic for people to want to deal with it. We do see sometimes that leading to a decision by the firm just to get rid of a mandatory retirement age and to rely on performance management, which is probably quite healthy in that circumstance if it is going to be too difficult to decide what the right one is. I mean, behind that, obviously, it suggests that there isn't a good commercial rationale for it anyway. So honestly, I think that the true answer to that question is most firms, or not most, a lot of firms see it as a really, really difficult issue to deal with.
Thank you. Emma, would you mind just giving us an overview of the framework, the age discrimination framework that needs to be addressed by firms when considering their mandatory retirement age provisions and where they have to justify them?
Yeah, so the starting point is the Equality Act, which prohibits direct discrimination on the grounds of age. And of course, the mandatory retirement age, on the face of it, is directly discriminatory. But direct age discrimination is unique amongst direct discrimination claims in that it can potentially be justified if it is a proportionate means of achieving a legitimate aim, which is language we're familiar with when we look at indirect discrimination. But the parameters within which you can justify direct discrimination are much narrower. And the leading case in this area is Selden against Clarkson, Wright and Jakes. That was a case which involved a mandatory retirement age of 65 in place a while ago when the default retirement age was still in place. So pre-Equality Act, it was abolished in 2011. So it's of its time, but it still sets out the sort of guiding principles that tribunals will look at and that employers and firms need to look at when they're looking at whether they can justify their mandatory retirement age. And the main principles are, when you're looking at a legitimate aim, it needs to be more than just what the needs of your business are, so more than just cost saving or competitiveness. It needs to have a sort of social policy element to it. And in Selden, the tribunal looked at, what sort of aims then would satisfy that, and fall broadly within two categories. So one is intergenerational fairness, which is things like succession planning, creating vacancies for younger staff. Also diversity, the idea being that younger cohorts are more diverse than older cohorts. And then dignity in the workplace, which is things like promoting collegiality across the different ages in your workforce. And it's a bit more problematic, this one, but avoiding unpleasant performance management of older partners. That there's inherent in that some discriminatory assumptions, so you need to be careful, but it remains a potential legitimate aim open to employers. So the next thing that Selden establishes is that once you've got your legitimate aim, the MRA actually has to be capable of achieving that aim, so it needs to be appropriate. And then you need to do a sort of balancing exercise where you look at the impact of that on older staff, which is obviously substantial because you're exiting them. And then the efficacy of the MRA, is it really achieving what you hope it to achieve? Is it effective? And also, are there any alternatives that are less discriminatory that could equally achieve that aim? And so you're required to do this balancing exercise to establish that it's reasonably necessary as well as appropriate. And fundamentally, the tribunals will expect you as an employer or as a firm to have evidence to back up that analysis. So you can't just rely on assumptions that the MRA is effective, that it's creating opportunities for younger people, for example. You need to look at actually how it operates in practice in your business. And the tribunals will expect that evidence at each stage of that test of justification.
So that's really interesting. Thank you. What we do see in practice is that some firms do put within their mandatory retirement age provision their stated one or more legitimate aims, like intergenerational fairness or workforce planning, etc. But sometimes when you dig a bit deeper, you find that actually there's not much more than that beneath it. And if you ask some of the partners, well, what was the process that went through that where you landed at that those one or more aims? And I think what's clear, including from a couple of the recent, two, three, the recent cases that I'd love you to just to talk about at a high level is that it's not enough just to have identified your legitimate aim and put it in your agreement. Even you literally have to. The tribunals are saying, show us the evidence.
Yeah.
Kind of where is it? What show us you're working out.
Yeah.
And that is a reasonably significant exercise. But before we get into that, so can you just give us that overview of, Selden caused the chilling effect. Nobody was really litigating around these previously, but now there've been some recent cases, and just give us a flavour of what those cases are and what they're asking firms and employers to show.
Yeah, I mean, fundamentally, what they're asking is this move away from a presumption that you need an MRA. And I think you're right. One of the things that leads to firms having the legitimate aims, but then not really being able to substantiate them, is they start from the wrong starting point, which is the assumption that they need it, and then let's just try and find evidence for that, rather than looking at their business and thinking, what needs do we have, and then are these legitimate aims? And the case law really shows this. There's some really interesting cases. The University of Oxford has had it's been in and out of the tribunal on this matter on a number of times. There's two cases, Pitcher, one claimant, and Newitt, another, that both concerned the mandatory retirement age when it was 67, with some option to extend. They were heard at around the same time, different tribunals, and had different outcomes. So in Pitcher, the mandatory retirement age was upheld. In Newitt, it wasn't. And the fundamental difference was the evidence that was produced by the claimant in Newitt. So the university's position was consistent, but in Newitt, the claimant had an expert statistician that really analysed and undermined fundamentally the university's position. So just to give you some highlights, it showed that the university said, well, the MRA causes a 4% increase in turnover. Statistically, that's not significant. And also, you couldn't really establish the causal link. University said more vacancies are produced by the MRA. But actually looking at it, a lot of them weren't even filled. So, how is this pursuing your legitimate aim? University said more women are being promoted to senior positions, but no evidence to support that was caused by the MRA. In terms of their extensions, I think about 30% of people due to retire were given extensions, and the rationale for that was inconsistent with the legitimate aim. So it sort of undermined the need for the MRA itself. And other universities are doing better or similar against these legitimate aims without an MRA. So the university then went back to the drawing board. It increased its MRA to 68. It reduced the scope of the extensions, but then still formal claims were brought. And again, these were all heard together, so we had the same outcome. But again, it wasn't justified. And it really sort of hammers home that the burden is on the employer to provide evidence to support its case. And here, the university had tried to do it. They had pulled together some mathematical modelling, looking forward as to what vacancies would arise in the future from this MRA. It's all very speculative, and fundamentally, the tribunal was very critical of that. They'd had this MRA in place for 10 years. They hadn't collated any real life, data as to what vacancies were created, how they were filled, what impact did that have in achieving the aims. They had ample opportunity to do it. So that was something that the tribunals were very critical about. There are all sorts of issues there, but it's really the direction of travel with the case law is showing that tribunals are pulling up their sleeves and they're really willing to get into the detail, and they want to see this robust empirical evidence, which employers have access to. They need to be looking at age data and exit interview feedback, and properly consulting and demonstrating on paper that they have weighed up all this evidence, and how that and not made assumptions about how efficacious an MRA might be in their organisation. And of course, you've got Scott and Walker Morris, which was decided earlier this year, which again really drives these principles home. In that case, Walker Morris had a retirement age of 60, which had been in place for a long, long time. And in essence, their position was, well, they'd agreed some extensions to that, where partners were able to demonstrate exceptional performance. There was an option to extend to 63 and then potentially to 65, but I don't think anyone got to 65, and it was very rigidly applied. And their position really was, it's been agreed by the partners, it's in the deed, it's been consulted on. The reason we don't have any issues in terms of progression is because this has been in place for so long and it's been so effective. And it was all sort of rather anecdotal. And the tribunal were very critical of that. The fact that it had been in place for a long time in of itself wasn't probative of anything. And in fact, looking at it, they had an issue with partner retention. I think over the next few years, they had so many partners due to leave because of this. It was creating the opposite issue than the one reflected in the legitimate aim. The requirement for exceptional performance in itself was discriminatory. Younger, people under the age of 60 didn't have to meet that higher threshold. And the evidence, a lot of it was just oral evidence. There wasn't any real written documentation showing the process they had gone through to reach the decisions that they had reached. And the oral evidence itself, had some discriminatory aspects to it. So assumptions about, older partners, as they age, they become less ambitious and their performance drop. There was nothing to back that up to show that that was an issue that the firm faced, and actually the firm really robustly managed performance. So for all those reasons, the tribunals were really critical. So we are really seeing this requirement for firms to grapple with the detail of their decision making and just not make assumptions. And I think the thing is that starting point, not to fall into the trap of saying, we need an MRA. This is what we think it should be now. How do we go about the business of justifying it? Actually, the starting point needs to be, let's look at our business. Where are there roadblocks? Where are there issues? And then think more broadly about what might help you address those issues. And an MRA may be one thing in your toolbox, but shouldn't be the presumption.
And there is a thing around the age as well. When you read the judgment in Scott and Walker Morris, you have a sense of their existing retirement age was 60, and there wasn't really an enthusiasm to change that. They were just really, they were kind of considering the circumstances in which they would make exceptions to it. And I know there was a lot of documentation, there was consultation, but it seemed to be consultation mostly around maintaining the status quo, but with some exceptions. Whereas I think what you're saying is you really have to look at it with fresh eyes and an open mind. Do we need one? Or if we do need one, at what age? What is the appropriate age? And it's really interesting that for Oxford University, and you have to be a little bit sorry for them that, they clearly did try, like 65, then 67, and then they went up to 68. And then it still wasn't enough. But it really shows how interventionist the tribunals are now. Yeah. Can I just very briefly ask you, before we come back to Corinne, you mentioned about extension. So we are seeing that a lot. There are a number of firms that do provide that opportunity to extend partners beyond the mandatory retirement age. And, you've got some interesting views about how they should be applied, because we sometimes see them being applied actually quite randomly and in an ad hoc basis, an inconsistent basis. So just give us your thoughts on that. That might be helpful to any firms listening who have those kind of provisions.
Well, the reason people have them is that the idea is we're not applying this so rigidly, so it reduces the impact on older partners. Therefore, it should be easier to justify. That's the sort of rationale behind it. But so in the Oxford case, we saw that actually it was being applied so frequently that it undermined the need for the MRA at all. And in the Walker Morris case, the criteria, apart from the fact the criteria was discriminatory in of itself, it was so narrowly applied, it didn't really have that effect of making the MRA less rigid. But the other aspect is the criteria for granting an extension, I think, really needs to be consistent with the legitimate aim that you've got the MRA for in the first place. So, in the Oxford cases, it was sort of, if the benefit of granting the extension is more important to us than the legitimate aim, then we'll grant it. So you can see how that fundamentally undermines the need for the MRA. So if your legitimate aim is succession planning, for example, and in one particular case, if that person is retired, there'll be an issue with succession planning. You can see that's consistent, and if it's for a limited period, then you're going to have a better chance at justifying it. But also, you need to look at, if you've had this in place for a while, are you granting so many extensions that actually you need to rethink the MRA and think we don't have the legitimate aim that we thought we did? Or is it really not an extension that is working in practice to help you justify your MRA?
So, Corinne, we are all about solutions here. Obviously, we've highlighted the risks, we've highlighted some of the market practices, but what about the proactive steps that firms can take to seek to justify their MRA, firstly? And then secondly, if you could just talk to us a little bit about alternatives. We've talked about having none at all, looking at sort of different ages. What are the sort of things that you think firms should be exploring?
Thanks, Claire. Well, sort of thinking about that first piece, let's think about process first. And I would just say, and it feels sort of fiercely pragmatic and very focused on the logistics, but I think it's really important to have a sort of a good team thinking about this. You probably need a range of people across the firm to be able to get people to engage on the issues, to understand the different topics within the firm, the different attitudes within the firm, and so on and so forth. We do see quite often partners leading on this, and I can see the logic there, but let's not forget as well that we have to have really, really great written records, so we have that body of evidence. So you need to make sure that that team is not only gathering the information and processing the information, gathering the evidence, also recording it, making sure it is, checking back against the aims, those sorts of things. So it has to be a really effective team that you have in place on a purely sort of practical level. So let's think about the types of evidence that we need to be gathering here to support this MRA if the firm is thinking about retaining one. We might think about evidence that shows the generational spread of the workforce, or the types of clients that you have. For example, clients all come through sort of self-generations of partners across the partner body, or is it more of a sort of an inherited client base, which might support the idea that, you need to sort of create space for the next generation by passing those clients down to the next generation of partners, for example. You need to look at what the challenges of the recruitment and retention of partners are. Things that you might look at there might include things like exit interviews. Why are people leaving the firm? What is the data actually showing you about the evidence for why people are leaving? Because if your exit interviews don't say, I'm leaving because I don't seem to be progressing through the partnership and I'm not looking likely to reach the senior echelons, then that's going to be hard to argue as a legitimate aim, I would have thought. You might also be able to look at recruitment data, for example. Why are people attracted to the firm? What sort of brings them into the firm, or encourages them to be promoted through the ranks, for example? You might talk about that in appraisals, for example. I think also law firms have a huge amount of data in their systems, in their practice management systems. For example, you can look at contribution, performance, those sorts of metrics using the time recording data. You can look at client generation. You can look at individual partners' contribution in that way. And I think that's a very technical data set that can be used. Now, don't forget that we're in this fantastic new era where AI and large language models are really helping us to analyze data in a way that we've never really been able to. Now, we've got to remain skeptical about hallucinations, of course, but those tools, I think, can be really useful to be able to ask it to analyze huge data sets that you'll have on your systems and see if any themes can be identified. And then, of course, you can stress test them as human beings as well. So that could be quite useful. I mean, surveys and consultations could be useful in terms of gathering that evidence as well. You should probably ask open questions rather than closed questions. I think when we're looking at this data, thinking about the next step, you sort of gather together this information. You also need to remember that data and evidence needs to be reviewed and critically assessed on a regular basis. So stress test those elements on a practical level. You might not do that with the full partner body on an annual basis, but you might, for example, ask a project team or the management team to look at that annually with perhaps a fuller partner-wide exercise on a 3, 4, 5 year basis. Again, it will depend on the specifics of the firm, but as I say, I don't think anybody would expect that to be an annual exercise with the entire body. I think that the other thing is also to think about how the business is evolving and whether that is affecting the starting point for your MRA. For example, we talked about business aims, and we've talked about what you're trying to achieve. It could be that the way that the business has changed means those aims have evolved. Let's again talk about AI. We might find that the adoption of AI means that the way in which we work is completely turned upside down. Does that mean that the age profile and the contribution at different ages and all the things we might be thinking about are affected by the adoption of AI and different technologies and the way the firm evolves? Again, that will be specific to the firms, but we can't assume that the business is static and therefore that the business aims are static throughout that process. So it's a multi-layered process, Claire.
And all of these obviously would form part of an ongoing consultation with the partner group. And I think what really comes through is that this is a project. This is not something that it's like one and done and it's quite brief checkbox. It's a really immersive project that needs to be looked at properly, led by the right team, looking at a broad range of evidence, and then kind of really having immersive consultation with the key stakeholders.
We also need to remember that we talked about consultation. Consensus is really important in terms of bringing the partners along with you. But we've also seen from the Walker-Morris case that having consent, even from everybody, is not enough to actually be comfortable that it is justifiable. So I take your point on consultation, but you've still got to stay on your toes.
Of course. And then just briefly about alternatives. Yeah. What are your thoughts on alternatives?
Thank you. Well, I mean, how long you got? I just sort of briefly thinking about some alternatives. I think a really good one is thinking about robust age-neutral performance management. And let's just step back from a minute. Why would a firm want to retain partners to a certain age if they are not performing at a younger age? Likewise, why would a firm want to remove partners if they are continuing to contribute really strongly, but if they've reached a certain age? I mean, a lot of firms will say that that's not how they want to operate. Therefore, that really tends to suggest that a performance management system for deciding who stays in the firm and who leaves is a really appropriate one for lots and lots of firms. What you need to support that working really effectively is actually good appraisals. And good appraisals involve delivering difficult messages sometimes. If someone isn't performing on a particular element of their role, then that needs to be recorded and that message needs to be delivered. I've lost count of the number of times we've advised clients where they've said, well, this person knows this is a problem, but we didn't really want to write about it in the appraisal because that seemed quite harsh. And then, of course, a number of years later, you then try and act on that particular factor, and the partner will say, well, I didn't understand it was that serious, or I didn't know, either genuinely or disingenuously, depending on the individual partner in question. And it also robs that partner of the opportunity to genuinely improve that aspect of their performance if they haven't got clarity on where the shortfalls lie. So I would encourage firms to beware of being too nice in those exercises. I think you can think about planning the partner body generally, looking at the composition of the partner body and not thinking about age as a factor, but thinking about how it works over a number of years. I worked with one firm that had a system that asked every partner to forecast when they thought they were going to retire. That was whether you'd been a partner for a year or you'd been a partner for 25 years. The idea there, it was based on the idea that actually we don't care what age people retire at. What we care about is having massive gaps in certain practice areas. And that could come about because somebody wanted to leave at 50 and somebody else wanted to leave at 75, but they both wanted to leave in 2026. So, that's where the problems lie. And I think that sort of exercise where you have an understanding of when people might retire, clearly not something you can hold people to, could be quite useful. And by asking everyone, it isn't targeting, say, older partners who might be speaking.
I do actually completely agree with that about having whole career discussions on an annual basis. And similarly, we do see firms where they provide, really excellent retirement coaching services, but they offer them or target them, depending on how you look at it, to people who hit 55. Yeah. Instead of, which, if you were 55, I mean, I'm 56, just saying, that you might feel a little bit sort of uncomfortable about the fact that you hit an age and then you're being offered this. It's almost like a bit of a hint. I personally think it's much better to offer that sort of retirement coaching option to any partner of any age, and it's entirely up to them as and when they want to take it up. And I know people have different views, and it could potentially be justified just to offer it to people at a certain age, like 55. But what's the harm in actually offering it to all partners just for when they want it and when they're ready?
That's a really good point, Claire. A really good point. Other things we might think about on the alternative scale is think about whether it's actually the mandatory retirement age which is the problem here. Are there other aspects? Is it the governance system, or is it the compensation system which is the problem? Because if your compensation system, for example, is weighted so that there's a real benefit to sitting at the top of a lockstep, for example, then of course people won't want to leave. And that could be a blocker. And it could be that actually, if there were changes to a compensation system, the firm might achieve its objectives more effectively than if they had alternative systems. So think more widely about where the issues lie and whether the MRA is genuinely a solution to those specific business issues.
What about things like, obviously we often see consultancy arrangements or dropping back to fixed share rules or part-time working arrangements? What role do they play?
We do see them a lot, but I think one of the things you have to be aware of is that they often include much less favourable terms than you would have had if you continued as a partner. So that sort of imposition of a different regime which is less favourable could sort of feed into the discrimination argument again, in the same way as exit could be in that element. So you need to be really thoughtful about that. And I think often we see that those consultation roles are offered because there hasn't been proper succession planning prior to exit. So it's almost we have to do this because there needs to be a handover. So I think I would just counsel firms not to have that as a substitute to a proper succession plan. It could be part of a proper succession plan, of course. Firms might want to think about maybe finite terms being as a partner, for example. Then it wouldn't matter what age you were. You would say, well, you were allowed a maximum of X years as a partner or an equity partner, or however your firm is structured. Might be quite useful. It might even promote sort of EDI objectives too, because we are hearing that people are having different career journeys now, and there might be people who've had time away from the partnership, might be with caring responsibilities, parental responsibilities. Often they fall to women, and therefore they might enter the partnership at a later age than maybe an equivalent man. Maybe. And in those circumstances, if you've got X number of years, it doesn't matter whether you join the partnership at a certain age or another age, for example.
Great, thank you.
I was just going to add one last, actually, if I can, Claire, and it's a bit of a curveball. But I also think that having a meaningful sabbatical system can be quite useful, because we often hear that partners are reluctant to embark on retirement. That's often because they don't know what it looks and feels like. And therefore, the ability for the partner to understand what not working feels like could be quite good, because I think they'll probably find they quite like it, despite being sort of so committed to their roles. But also, I think it's really positive for the business, because it gives space between the partner and the business. The business is not wholly reliant on that partner. There's business continuity benefits. It means that clients establish relationships with other partners. So I think that if the firm can afford to run a system like that, there can be real benefits to having sabbaticals in terms of aiding that sort of natural desire to retire.
It's a brilliant suggestion. Thank you. Emma, do you think you could just give us just a final quick overview of why it's so important for a firm to really do everything they can to get this right? I guess, what are the downsides, if it doesn't quite go in the way you want and you end up in the kind of Oxford University, Walker Morris type situation in the employment tribunal?
Well, obviously there's, legal risk if you get, you get a finding against you for direct discrimination. And as we see in the University of Oxford cases, these are claims that can be brought by more than one claimant. So there's a financial implication to that, claims for discrimination around caps. There's the litigation costs associated with it. There may be insurance implications if you have a policy in place which is not lawful. Reputational implications. I think it might suggest that the firm's a bit old-fashioned if it's got, the culturally we're moving away from assumptions about age, and so if it has an MRA in place which is shown to be problematic, that can have reputational issues, problems with retention or recruitment of partners. The SRA may be interested in it, might bring your culture under scrutiny in terms of non-discrimination, ethical leadership and transparency. But also just looking at it from a commercial perspective, if you think you need this because it's addressing an issue in your business, but in fact it isn't, and that issue might be best addressed by one of the many other ways that Corinne touched on, that's something that you need to know. So I think that there's an opportunity here, done right. It really will enable you to get to grips with what your business needs are and actually what is going to work for you, and avoid getting rid of good performing partners simply because of their age, when doing so isn't achieving what you think it is achieving.
Great. Thank you so much. Well, look, thank you so much for staying with us to the end of this recording. I hope you've enjoyed it. If you have any questions on this area, if your firm is actively sort of revisiting your mandatory retirement age because of, say, the recent Walker-Morris decision, which I know many are, then please do feel free to reach out, and we're very happy just to have a sort of like a low-key chat, just to give you a steer on what we're saying and how you're approaching it. Thank you to Emma. Thank you to Corinne. That was really interesting. What's clear is it's a very nuanced situation. There aren't necessarily absolutely right or wrong answers. It's about your firm and the strategic needs and imperatives of your business, and making sure that you've got the evidence to back that up. So I really appreciate all your thoughts and contributions today, and thank you again for watching. Hope to see you again soon. Thanks. Bye-bye.
Bye.